Yes, I salute you all, and thanks for watching. Thank you for being always on. By name, I'm Matalo Simon Peter, as always. And today's major topic of emphasis is the topic of love. What? Love of evidence. And basically today we shall talk about the preamble. What is evidence law composed all about? What is evidence law all about? How can someone best understand what they mean by evidence law? Basically, evidence law, for it, or what you have to bear in mind, it deals with both the public and the private law. You get what do I mean by both the private and public law? It deals both to the public and to the private individual or personnels. It also deals with both criminal and civil cases. That is the law of evidence. It deals in both. However much the standards of evidence, or the other one is a burden beyond reasonable doubt under criminal, whereas under civil it is on the balance of probabilities. So the way you prove your evidence differs, but evidence law applies to both the criminal and civil, both public and private law. And a good definition of what they mean by evidence law basically may refer to the statements or circumstances that the court uses to prove or disprove a given fact in a dispute or a given fact in a situation. So basically that is the good definition that I can give. Basically, it may be in the form of a testimony, it may be in the form of a confession, it may be in any other form, or like an opinion of an expert opinion that we shall be seeing in front there, that surrounds the circumstances given to a particular case or a particular situation. So basically that's to deal with evidence law. Evidence law, actually, it is composed of many things. It's composed of photos, documents, composed of any physical objects or any situation that may deal or may bring a certain evidence to prove a particular fact or a fact in issue. If it is murder, it may be a photo, it may be objects, a cigarette, a knife. Those are all composed under the law of evidence. And basically, there are certain categories under the law of evidence. There is admissibility. Admissibility, here the question that asks that will court admit the evidence that is brought? Court admits any evidence so long as it forms part of the issue. It may be irrelevant, but it becomes relevant once it is in the same transaction to the fact in issue, as we shall see rest time in our discussions, in our subsequent discussions. And also we have admissions and confessions. Admission also, it is under civil, and confessions under criminal. But nevertheless, an admission is taken during the court or during the trial, whereas a confession is taken prior to the trial. So basically, note that difference between the two. Then when you continue and realize we want to know where the development of the law of evidence, where did the law of evidence originate from? Actually, the development of the law of evidence in Uganda, basically, we had our norms before, but the white man came with these laws. And basically here, what you have to put in mind, or what you have to bear in mind, is that the law or the courts, for them to come to their judgment, they base on the law of evidence. You get through the process, and their reasoning bases on the law of evidence. That's why they give a rational reasoning to their judgment. And basically the law of judgment, like any other law, it was originated from the Britain under the 1902 order in council that was brought in Uganda, that was imposed in Uganda. That's where the law of evidence came from. And the procedures or bringing that law, it brought in different procedures in the courts of judicature, or in the courts of in the courts of law. Basically, it seized or it seized and censored the different forms of law, of the different methods of proof. For example, trial by battle and trial by ordeal. Those were censored when the 1902 Order in Council was brought or was proclamated in Uganda, basically. Because we had our traditional norms on how to prove that someone did a particular fact traditionally, but they were removed by the 1902 Order in Council that brought the evidence law. And here we realize that the Order in 2 transported many foreign procedures and transported basically to actually it brought those foreign procedures of law of evidence that so that they can conform in the legal sector of the Ugandans or the traditions of in the Ugandans. Unfortunately, the rules of evidence that we have brought, the white man brought them not bothered to know whether they would conform with our traditions or norms. You get? For them, they were unbothered. They just imposed their laws to us. That's how we get the law of evidence. And basically, there's a good man who's called Bentham. Bentham, this was a man from Britain. Actually, for him, he says that according to him, the law of evidence deals with the deals with the persuasion concerning the existence of a matter of fact. It persuades to persuade something to a matter in fact. For him, that's Bentham, that's what he says, that deals with the persuasion of a matter of fact. Bentham also further laments, he says that it does not consider, his evidence law is not a concept and is employed basically to the courts of law. And for it, actually, he says that it relies on the human activities, both scientific and non-scientific. Basically, not that in mind. For him, he says that it deals with the human the human activities, both scientific and non-scientific. And also, he also continues still that Bentham, who was a Britain man, a legal scholar. For him, also says that the word, that evidence is defined as a word in relation to the meaning of any matter. You get any matter of fact, tendency, or design, of which when presented to the mind, it is to produce a persuasion concerning the existence of some matter of fact. Basically, that not that in mind.